I have a handicap placard. It's hanging right there.
I need to see proof you're actually disabled.
Proof? I'm in a wheelchair.
A lot of people fake disabilities to use these spots.
Are you seriously asking me to prove I'm disabled while I'm sitting in a wheelchair?
No.
Sir, you need to move this vehicle. Now. The voice carried that particular edge, not quite shouting, but sharp enough to cut through the mid-morning air. Officer Derek Pullman stood with his thumbs hooked into his duty belt, chin slightly elevated, eyes narrowed behind cheap polarized sunglasses that reflected the disabled parking placard hanging from the rearview mirror. I have a valid placard, the driver said, his tone even, almost clinical. I'm parked legally in a designated accessible space. I don't care what you think you have. Pullman stepped closer to the driver's window, his shadow falling across the man's face. I'm telling you to move. People like you abuse these things all the time. People like me. It wasn't a question. The driver's hands remained visible on the steering wheel, 10 and 2, fingers relaxed. His expression hadn't changed. Calm, measured, the kind of calm that comes from practice. You heard me. Pullman tapped the roof of the car twice, each strike deliberate. Move it or I'll move it for you. Your choice. The driver reached slowly toward the center console. Pullman's hand drifted toward his holster. I'm retrieving my documentation, the driver said, his voice dropping half an octave. You might want to wait before you do something you can't undo. Pullman smirked. Is that a threat? No, officer. It's advice. It was a Tuesday morning in Greendale, a mid-sized city in the Midwest where strip malls outnumbered parks and the police department operated with the kind of autonomy that thrives in communities that don't ask too many questions. The incident occurred outside a municipal services building, a squat, beige structure housing everything from parking enforcement to health permits. The parking lot was half empty, plenty of spaces, no congestion, no emergency. Officer Derek Pullman, 38, had been with the Greendale Police Department for 14 years. He'd worked patrol, traffic enforcement, and briefly served as a school resource officer before being reassigned. Quietly, after complaints from parents about his interactions with Black and Latino students. Nothing formal, nothing that made the news, just the kind of internal shuffling that keeps lawsuits at bay and unions happy. Pullman had a reputation. Not the kind that gets you promoted, but the kind that gets tolerated. Other officers knew he was old school, which was code for something else entirely. He'd been named in 3 excessive force complaints, all marked unfounded or not sustained. He'd been recorded twice making comments about those neighborhoods during roll call. His body camera had a curious habit of malfunctioning during contentious stops, 17 times in 2 years, according to later audits. But on this particular morning, his camera was working perfectly. The municipal building parking lot had 6 accessible spaces near the entrance, each clearly marked with international symbol of access pavement markings and vertical signage meeting ADA height requirements. The spaces were almost never full. On this Tuesday, only 2 were occupied. One by a woman with a walker, the other by a Black man driving a late-model sedan. Clean, well-maintained, unremarkable except for the disabled placard visible through the windshield. Pullman had been parked across the lot, ostensibly running speed enforcement, though the lot had a posted limit of 10 miles per hour and traffic was minimal. He'd been scrolling through his phone, drinking coffee from a travel mug, the kind of detail that shows up later in depositions, time-stamped and humiliating. Then he saw the sedan pull into the accessible space. He watched the driver, a Black man, mid-40s, wearing business casual attire, exit the vehicle. The man moved carefully, using the car door for support, his left leg dragging slightly as he stood. He reached for a cane in the back seat. The placard swung gently from the mirror, laminated and official, the expiration date clearly visible. Still valid for another 8 months. Pullman started his patrol car and drove across the lot. What happened next would cost the city $750,000. End a career, trigger a federal investigation, and put Pullman behind bars for 16 months. But in that moment, sitting in his cruiser with the engine idling, Pullman felt something else entirely. Certainty. the comfortable, unchallenged certainty of someone who'd never faced real consequences. He stepped out of his vehicle and approached. Would the interaction have been different if the driver had been white? That's the question that haunted the subsequent investigation. Marcus Thornton was an attorney. Not just any attorney, a civil rights litigator with 12 years of experience, a Harvard law degree, and a practice focused almost exclusively on Section 1983 claims. Federal lawsuits alleging constitutional violations by government officials. He'd won settlements against 3 different police departments. He'd testified before state legislative committees on qualified immunity reform. He'd published law review articles on Fourth Amendment seizures and the legal framework of discriminatory enforcement. But on this Tuesday morning, he was simply a disabled man trying to attend a zoning hearing. The disability was real. A car accident 4 years earlier had crushed his left tibia and fibula, requiring 3 surgeries and 18 months of physical therapy. He still walked with a pronounced limp. He still experienced chronic pain that flared unpredictably, turning good days into white-knuckle endurance tests. He'd applied for the disabled placard through proper channels, submitted the required physician certification, and received it without issue. He used it only when necessary. Today was necessary. Marcus had noticed the patrol car in his rearview mirror as he pulled into the lot. He'd noticed the officer watching. He'd felt the familiar tightness in his chest. Not fear, exactly, but the exhausting hypervigilance that comes from years of being perceived as threat first, human second. He'd checked his placard. Still hanging. Still visible. Still valid. He'd exited the vehicle slowly, deliberately, making his disability obvious. The limp wasn't something he could hide, and he'd learned long ago not to try. He'd reached for his cane. A simple black aluminum model, telescoping, purchased from a medical supply store and kept in the back seat for days when his legs simply wouldn't cooperate. Then he'd heard the voice. "Sir, you need to move this vehicle. Now." Marcus had turned, one hand still on the car door, the other gripping the cane. He'd seen the officer approaching with that particular stride, not rushing, but purposeful, projecting authority like a force field. He'd seen the sunglasses, the crossed arms, the body language that said compliance is not optional. He'd also seen the body camera, clipped to the officer's chest, its tiny red light blinking steadily. "I have a valid placard," Marcus had said, keeping his voice level, his hands visible. "I'm parked legally in a designated accessible space." And that's when it started. Pullman had stepped closer, invading the personal space buffer that cops are trained to respect during non-threatening encounters. "I don't care what you think you have. I'm telling you to move. People like you abuse these things all the time. People like you." Marcus had heard it before. Different words, same meaning. The assumptions baked into the tone, the casual dehumanization that happens so smoothly it almost sounds polite. He'd litigated cases built on exactly this kind of language. He knew what it meant and he knew what it could cost. Not him, but the person saying it. He'd also known something else. He was being recorded. Not just by Pullman's body camera, but by his own phone, which he'd activated using voice commands through his car's Bluetooth system before exiting the vehicle. The audio was already uploading to secure cloud storage, time-stamped and encrypted. But he hadn't said that. Not yet. Instead, he'd remained calm, precise. He'd let Pullman talk. He'd let Pullman escalate. He documented every word, every gesture, every violation of department policy and constitutional law, because that's what Marcus did. That's what he'd been trained to do. He was a man who understood power, not the theatrical kind that comes from a badge and a gun, but the quiet, irreversible kind that comes from knowledge, documentation, and the law applied without mercy. Pullman didn't know this yet. What would you have done in Marcus's position? Would you have stayed calm? The officer tapped the roof of Marcus's car twice, each strike deliberate, almost mocking. "Move it or I'll move it for you. Your choice." Marcus reached toward the center console slowly, telegraphing every movement. His fingers moved with deliberate precision, the kind of care that comes from knowing a single misinterpreted gesture could justify violence. The leather of the console was warm under his palm. The car had been sitting in morning sun, and the heat had soaked into every surface. Pullman's hand drifted toward his holster. "I'm retrieving my documentation," Marcus said, his voice dropping half an octave. "You might want to wait before you do something you can't undo." "Is that a threat?" Pullman's smirk was visible even behind the sunglasses, a curl of lip that spoke to years of unchallenged authority. "No, officer. It's advice." Marcus produced his driver's license, vehicle registration, and insurance card. Then, carefully, he unhooked the disabled placard from the rearview mirror and held it toward the window. The laminated card caught the light, the state seal clearly visible, the expiration date printed in bold. August 2024. It was January 2024. Pullman barely glanced at it. "That could be fake." "It's not. I'll determine that." Pullman snatched the placard through the window, his fingers brushing Marcus's with unnecessary force. He held it up, squinting, turning it over as though expecting to find some obvious forgery. The state-issued hologram was intact. The serial number was embossed. Everything was legitimate. But Pullman's jaw tightened. He'd committed now. Backing down would mean admitting he'd been wrong, and the architecture of his ego simply didn't allow for that possibility. "Step out of the vehicle," Pullman said. "On what grounds?" "I don't need grounds. I'm conducting an investigation." Marcus could feel his leg throbbing. A dull, persistent ache that radiated from his shin to his knee, the kind of pain that would worsen if he stood too long. The morning had started as a good day, pain-wise. That window was closing. "An investigation into what specific violation?" Marcus asked. His hands remained visible on the steering wheel. His voice remained level. "Clinical. I've presented valid documentation for my vehicle and my placard. I'm legally parked in a space I'm entitled to use. What articulable, reasonable suspicion do you have that a crime has been committed?" The legal language landed like a slap. Pullman's expression shifted. Not quite confusion, but irritation at being challenged by someone who clearly knew the terminology. "You're being argumentative," Pullman said. "That's obstruction. Asking for legal justification isn't obstruction. It's a constitutional right. Out of the car. Now." Marcus complied. Slowly. He opened the door, swung his legs out, the left one stiff, uncooperative, and used the door frame to pull himself upright. His cane was still in the back seat. He reached for it. "Leave it," Pullman barked. "I need it to walk." "I said leave it." Marcus straightened without the cane. His weight shifted entirely to his right leg. The left trembled slightly, the muscles unable to fully support him without assistance. He could feel the cold metal of the car door under his palm, the only thing keeping him stable. Pullman circled him, eyes scanning, looking for something, anything, to justify what he was doing. Marcus's clothing was professional. Pressed slacks, a button-down shirt, polished shoes. No sagging pants. No suspicious bulges. Nothing to feed the narrative Pullman was trying to construct. "You got ID?" Pullman asked. "I already gave it to you. Don't get smart with me." A woman emerged from the municipal building, mid-50s, white, carrying a purse and a folder. She slowed as she approached her car, 2 spaces away, her eyes darting between Marcus and the officer. She said nothing. She didn't need to. Her discomfort was palpable, a silent witness to something she instinctively recognized as wrong but lacked the courage, or perhaps the understanding, to interrupt. Should bystanders intervene when they witness police misconduct? What's the risk? Pullman noticed her watching. His posture straightened. His voice grew louder, performing now, asserting dominance for an audience. "I'm going to search your vehicle. Under what probable cause? I smell marijuana." The lie was so casual it was almost impressive. There was no smell. Marcus didn't use marijuana. His car smelled like leather cleaner and the faint residue of the coffee he'd spilled 2 weeks earlier. But the magic words had been spoken. "I smell marijuana," the universal skeleton key cops used to justify searches that had no legal foundation. "You're documenting this, correct?" Marcus asked, nodding toward the body camera. "Don't worry about my camera." "I'm not worried. I'm asking if it's activated." as required by your department policy during all law enforcement contacts. Pullman's jaw worked. The red light was blinking. The camera was on. And somewhere in the reptilian part of his brain, a warning signal was finally beginning to pulse. But pride is a hell of a drug. Turn around. Hands on the vehicle. Marcus complied. The car's hood was sun-warmed, almost hot against his palms. He could feel the rough texture of the paint, the slight vibration from the engine that had only recently been turned off. His left leg was screaming now, the pain sharp and insistent, climbing toward unbearable. Pullman patted him down. Not the professional, efficient search taught in academy, but something slower, more invasive, hands lingering at the waistband, the pockets, the ankles. It was designed to humiliate, to remind Marcus of his powerlessness. You got anything on you I need to know about? Weapons? Drugs? No. You sure about that? I'm certain. Pullman stepped back, radioing dispatch. His voice carried across the parking lot, sharp and official. I've got a subject detained for investigation. Possible fraudulent use of a disabled placard. Request backup for a vehicle search. Fraudulent use. The words hung in the air, absurd and insulting. The placard was real. The disability was visible. But none of that mattered because Marcus was black, and Pullman had decided, before any conversation, before any documentation, that he didn't belong in that parking space. The backup arrived 6 minutes later. A younger officer, barely mid-20s, fresh-faced and uncertain. He approached with his hand near his weapon, eyes wide, scanning Marcus as though expecting a threat. Pullman briefed him quickly, voice low, gesturing toward the car. The younger officer hesitated. Does he have the placard? He's got something. Could be fake. Did you run the serial number? Pullman's silence was answer enough. The search began. 2 officers rifling through Marcus's glove compartment, his trunk, his back seat. They found nothing. No drugs. No weapons. No contraband. Just a briefcase, a gym bag with workout clothes he hadn't used in months, and a case file for the zoning hearing he was now going to miss. Pullman held up the case file, flipping through pages of legal documents. What's this? Work, Marcus said simply. What kind of work? Legal work. And that's when Marcus decided the education period was over. I'm an attorney, Marcus said, his tone unchanged, still calm, still clinical. I specialize in federal civil rights litigation under 42 U.S.C. Section 1983. I sue police officers who violate constitutional rights. The parking lot seemed to contract. The younger officer froze mid-search, a folder still in his hands. The woman who'd been watching from 2 spaces away stopped pretending not to stare. Even the morning air felt heavier, oppressive, as though the atmosphere itself had absorbed the weight of what had just been said. Pullman's smirk flickered. So, Marcus continued, his voice taking on a lecturer's cadence, you've just committed several actionable violations on camera. You detained me without reasonable suspicion. That's a Fourth Amendment seizure. You ordered me to exit my vehicle without articulable facts supporting criminal activity. You conducted a pat-down search without consent or justification. You denied me my mobility aid, which constitutes disability discrimination under the ADA. You fabricated probable cause by claiming to smell marijuana, which is testifying to a false material fact under color of law. Pullman's face had gone pale beneath his tan. The sunglasses came off. His eyes, suddenly small, suddenly uncertain, darted toward his body camera, then back to Marcus. You refused to verify the placard's authenticity through proper channels, Marcus continued, each word precisely placed, building toward an inevitable conclusion. You racially profiled me based on visual assessment. You escalated a lawful parking situation into an unlawful detention. And you did all of this while wearing a badge, which elevates every single action into a federal civil rights violation. The younger officer stepped back from the vehicle, his hands now empty, his face flushed. He looked at Pullman with something close to horror, the expression of someone realizing they've just been made an accessory to career suicide. I don't care who you think you are, Pullman said, but his voice had lost its edge. It sounded hollow now, defensive, the last gasp of an ego that hadn't yet accepted its own destruction. "You should care," Marcus said quietly, "because I'm also the attorney who won Hendricks versus Greendale PD in 2021. $340,000 settlement. Excessive force. The case that led to your department's consent decree with the DOJ. I'm the attorney who deposed 3 of your colleagues last year. I know your policies. I know your training standards. I know what your insurance carrier requires for qualified immunity defense." Pullman said nothing. There was nothing to say. The foundation had already cracked. "And I know," Marcus said, his tone sharpening for the first time, "that you've been named in 3 prior excessive force complaints. I know your body camera has a suspicious malfunction rate. I know you were reassigned from the school resource position after complaints from parents. I know all of this because I've sued your department before, and I read the discovery." The silence that followed wasn't dramatic. There was no thunder, no sudden music, just the quiet, irreversible sound of consequences arriving. Pullman's hand trembled slightly as he handed back the placard. "You're free to go," he muttered. Marcus took the placard. "No, officer. We're just getting started." Marcus didn't leave the parking lot. He sat in his vehicle for 20 minutes, his phone pressed to his ear, speaking with his paralegal. He downloaded the footage from his cloud backup. 17 minutes of audio, crystal clear, time-stamped and geotagged. He photographed his disabled placard against the dashboard, the serial number visible. He documented the visible strain in his left leg, the tremor that hadn't stopped since he'd been forced to stand without his cane. Then he drove to his office and began drafting the complaint. The lawsuit was filed in Federal District Court 48 hours later. Marcus Thornton v. City of Greendale, Officer Derek Pullman, individual capacity, and Officer James Chun, individual capacity. 8 counts. 4th Amendment unlawful seizure, 4th Amendment unlawful search, ADA discrimination, violation of civil rights under color of law, intentional infliction of emotional distress, negligent supervision, municipal liability under Monell, and false testimony. The complaint was a surgical dismantling. 37 pages, 17 exhibits, body camera footage, audio recordings, dispatch logs, Pullman's personnel file, obtained through previous discovery in unrelated cases, and a timeline so precise it left no room for interpretation. The city attorney received the complaint on a Friday afternoon. Her name was Linda Vasquez, a competent lawyer who'd spent 8 years defending the city against everything from slip-and-fall claims to employment disputes. She'd seen plenty of police misconduct cases. Most settled quietly. Some went away with qualified immunity motions. A few made it to trial, and the city usually won or settled for nuisance value. But this was different. She read the complaint once, her coffee going cold on her desk. Then she read it again. Then she pulled Pullman's personnel file, the body camera footage, and the department's ADA compliance policy. She sat in her office as the sun set, the fluorescent lights buzzing overhead, her stomach sinking with each page. The city had no defense. Pullman's body camera had captured everything. Every word, every gesture, the illegal detention, the fabricated probable cause, the ADA violation when he denied Marcus his cane, the younger officer's hesitation, which proved even a rookie recognized the stop was wrong. And worst of all, worst of everything, Pullman's own words, "People like you abuse these things all the time." Vasquez knew what a jury would hear. She knew what those words meant. She knew that no amount of legal maneuvering could erase them. She called the city manager at 7 p.m. "We need to talk about the Thornton case." The meeting happened Monday morning in a windowless conference room that smelled of stale coffee and anxiety. Present, the city manager, the police chief, the HR director, the city's insurance carrier representative, and Vasquez. The body camera footage played on a screen mounted to the wall. No one spoke during the playback. The only sound was Pullman's voice, arrogant and dismissive, echoing through cheap speakers. When it ended, the insurance representative closed his laptop. "We're settling," he said flatly. We have no choice. The police chief started to object. We can fight this. Qualified immunity won't apply, Vasquez interrupted. The law was clearly established. Multiple circuit courts have ruled that detentions without reasonable suspicion violate the Fourth Amendment. The ADA violation is black and white. And the plaintiff is an attorney who's beaten this department before. He knows our weaknesses better than we do. What's he asking for? The city manager asked, though his tone suggested he already knew the number would hurt. He hasn't made a demand yet, Vasquez said. But based on comparable cases, given the video evidence, the clear violations, the plaintiff's credibility, and Officer Pullman's history, we're looking at $600,000 minimum. Possibly more if this goes to trial and a jury gets angry. The room fell silent. The kind of silence that follows a terminal diagnosis. The insurance representative pulled up a spreadsheet. Our policy covers up to $1 million per incident, but our deductible is $100,000. If we settle for $675,000, the city pays the first $100,000. We cover the rest. If this goes to trial and we lose, and we will lose, the verdict could be $2 million or more, plus attorney's fees, plus costs. The city would be on the hook for everything above the policy limit. The police chief's jaw tightened. What about Pullman? He's uninsurable in individual capacity, the insurance rep said. If the plaintiff gets a judgment against him personally, Pullman's wages get garnished for the rest of his career. His house, his pension, all of it's vulnerable. Pullman was terminated 6 days later. The department called it a policy violation, a bloodless term that erased 14 years of unchecked behavior in a single sentence. The settlement was reached before depositions. The city paid $675,000. Pullman faced no criminal charges initially. Qualified immunity didn't protect his job, but the local prosecutor declined to file until the DOJ got involved. The federal investigation began 3 weeks after the settlement. The Department of Justice Civil Rights Division requested Pullman's complete personnel file, all body camera footage from his previous 3 years of service, and internal affairs records for every complaint filed against him. What they found wasn't one bad stop. It was a pattern. 17 body camera malfunctions during stops involving minorities. 8 complaints of excessive force, all marked unfounded by internal affairs despite witness statements. 12 traffic stops with no documented probable cause. And testimony, buried in old depositions from Marcus's previous cases, where Pullman had made statements under oath that contradicted his own reports. Perjury, fabrication of evidence. Civil rights violations under 18 U.S.C. Section 242. Pullman was indicted 11 months after the parking lot incident. He pled guilty to 1 count of deprivation of rights under color of law in exchange for the other charges being dropped. The federal judge sentenced him to 16 months in federal prison and 3 years of supervised release. The Greendale Police Department entered a consent decree with the DOJ. Mandatory bias training. Body camera audits, civilian oversight, the kind of systemic reform that arrives only after the damage has already been done. But here's the deeper question, the one that lingers long after the verdict and the settlement and the press releases. How many others didn't have Marcus's knowledge? How many people were detained illegally, searched without cause, humiliated in parking lots and traffic stops and street corners, but lacked the legal expertise to fight back? How many accepted the violation because they didn't know it was a violation? How many times did Pullman do this before he finally did it to someone who could destroy him? The system didn't protect Marcus. His knowledge did. His documentation did. His ability to speak the language of constitutional law and federal litigation. Those were the things that saved him. And that's the problem. Justice shouldn't require a law degree. The parking lot outside the municipal building looks the same now. 6 accessible spaces, clear markings, the same beige building, the same strip mall across the street. But the department policies are different. Officers are required to verify disabled placards through dispatch before making contact. Body cameras can't be turned off during any law enforcement interaction. And every stop requires documented reasonable suspicion, recorded and reviewable. Marcus still practices civil rights law. He still sues police departments. He still walks with a cane on bad days. His leg a permanent reminder that vulnerability and power can coexist in the same body. And somewhere, in a federal prison, Derek Pullman has 16 months to consider the cost of arrogance. If you found this story important, consider subscribing. These cases happen more often than you think. And documentation is the only thing that makes the difference. What would have happened if Marcus hadn't been an attorney? Would we even know his name?